Hi, I'm Teresa Yao. I'm an estate planning attorney with TuckerAllen. Thank you for joining us today for Bypass Panic with Good Estate Planning. First, we'll take a look at our handout materials. Then I'll give you some insight on my own background. We'll identify the items that you want to know, discover how to create a worry-free estate plan, and we'll learn how to create your own action plan. In the description of this video, you'll find your handout materials, which will include your notes, some information on future seminars, and also some information on TuckerAllen. My background is very family-oriented. I'm very close with my grandparents, and I got into estate planning because I saw how important it can be for older adults. Based on previous seminars, we've gathered the most common questions that people have. Can I protect my assets from government, long-term care, and family? And if so, how? What is a trust? And what's the difference between revocable and irrevocable? How can I avoid probate? And do I need to? Can or should I give my assets to kids or other people? If I give my assets away, will it take 60 months for them to be safe? What is a power of attorney, a living will, or a healthcare proxy? What are the differences between them, and do I even need them? How can I plan for my disabled beneficiaries? Are my IRAs safe, and do I need special planning for them? And lastly, how can I avoid estate taxes? Did you know that only 4 in 10 adults have a will or a trust? And only 10% of those plans do accomplish their goals. So make sure that you aren't in that other 90%. The goals of our presentation are to identify if your current plan meets your goals, to understand what it takes to protect you and your assets, and to show you how to get what's missing. Here are the 3 steps to take to help you protect you and your estate. Number 1, know your rules. Number 2, know your risks. And number 3, know your options. So number 1, know the rules. The government has 2 sets of rules, one for when you're alive and one for after you pass away. Here are the government rules for when you're alive. These rules determine to whom you can grant authority, with tools such as the power of attorney, the healthcare proxy, and the living will. But what if you don't have these instruments and you were to become incapacitated? Well, the court will draw you into an arduous process called the guardianship hearing, where they will have 2 doctors come in to testify as to your incapacity and appoint a guardian or a conservator for you. All right, so here are the rules for after you pass away. Your last will and testament allows you to appoint who is in control, who gets your assets, and an important thing to note about a will is that it doesn't let you avoid probate. And probate is the legal process where the government has a lot of control about what happens to your assets after you pass away. And there can be significant delays with a minimum of 8 to 9 months just to process all the different assets. It can take up to 1.5 years to 2 years. And anything in probate also becomes a public matter, meaning that anybody can just walk into the courtroom while the judge is going through your assets and listen to what they are and listen to who's getting what. And also, the costs of probate can be pretty prohibitive. It's around 5 to 20% of your total estate. It's really important to distinguish the difference between documents and planning. For example, your financial power of attorney is a document, but you need to consider whether it's powerful enough or if there are enough instructions so that your agent knows how you want your assets to be taken care of. Another example are your healthcare documents. This is your healthcare power of attorney and your living will. But what makes it a plan is that you can tailor those documents to meet your organ donation wishes and make sure that they're HIPAA compliant so that your medical agents have access to your medical records so that they can make informed decisions for you. And also you can include personal care plans so that your healthcare agent knows how to kind of upkeep and maintain your life, even if you're not able to do so anymore for yourself. Remember the last will and testament? If your estate plan does involve probate, this is an instruction sheet you give to the probate court judge. A comprehensive estate plan provides more coverage against risks than just 1 or 2 documents can provide on their own. Think of each segment of an estate plan as bricks in a wall. If you have holes in your plan, then you have holes in your wall, which leaves you vulnerable to risks. So you want to make sure that your estate plan is comprehensive, a solid wall where no risks can come through. Step 2, know your risks. I like to categorize risks in 4 buckets: government, long-term care costs, your family, and also lawsuits. Government presents some of the risks we talked about earlier, such as the guardianship and conservatorship hearing, the probate process, and also the costs of estate administration. Long-term care costs are another of those risks that you should watch out for. Stay-at-home care can range from $500 to $12,000 a month. Assisted living can range from $2,000 to $5,000 a month, and nursing home stay can range from $5,000 to $12,000 a month. And if you were to need long-term care, do you know how you would pay for it? You've probably heard of Medicaid, but you've probably also heard rumors that they can take your home, that you have to give your assets away in order to protect them, and that you have to wait 60 months before you can get coverage. Medicaid has a complex set of rules and exceptions to those rules and exceptions to those exceptions. When you apply for Medicaid, any transfer of assets below fair market value within the last 5 years would subject you to penalties. The third and fourth category of risks are the unanticipated risks, which include your family and lawsuits. Nowadays, there are more and more blended families, which means more unanticipated risks coming from the different family relationships. And lastly, lawsuits are another category. For example, if you are driving and happen to cause an accident, you want to make sure that your assets are protected from any lawsuits that may arise. Step 3, know your options. I like to think of elder-based estate planning as driving a train through the different stations of life. You determine who's in control or conducting the train. You determine who's to benefit or who are the passengers on your train. And you decide what happens at the different stations in your life. 3 typical goals are staying in control, making sure that you don't feel like a burden to your loved ones, and keeping it simple. In order to meet your goals, our goals are for you to know the difference between documents and planning, to understand all the costs and how to minimize them, and to know the option and choose the right plan for you. Option 1 is to use the government's process, which I'm sure you're familiar with by now. And option 2 is to plan for your long-term care costs, which we covered as stay-at-home care, assisted living, or nursing home care. This can be accomplished by privately paying, getting long-term care insurance, getting community Medicaid, or if you're a veteran, you can get aid and attendance within 30 days. When it comes to Medicaid, you have 2 options. You have crisis planning and pre-planning. If a crisis occurred, would you qualify for Medicaid? Or what if you plan now when you're still healthy? If you intend to plan for long-term care, then we really encourage you to meet one-on-one with our attorneys so that we can develop really tailor-made plans for your situation. And if you plan now, you can more thoroughly lay out your wishes and potentially avoid that penalty period with Medicaid later. The most common way to protect your assets is with the right trust. There are 2 main types of trust: testamentary and living. Testamentary trusts are trusts that are created through your will, and living trusts are created while you're still alive. Now that you know your options, we encourage you to take these 3 steps. Step 1, create your rules in a will or a trust. Step 2, integrate those rules with your life and your assets. And step 3, maintain those rules as your life and the law changes. Without all 3, your rules usually become ineffective. Integrating your rules can involve retitling your house or stocks and bonds or your bank and brokerage accounts into your estate planning instrument. So you've already done the work in creating your rule book and integrating your assets, but things change and you need to be ready for that. The key takeaways for today are that documents alone do not make a plan. An incomplete plan is like a wall with bricks missing. And a comprehensive estate plan is like a solid wall that can protect you from outside risks. Next steps for you to take are to arrange an initial consultation with one of our attorneys so that we can talk about your individual estate planning needs. TuckerAllen is committed to no surprises, so you can view all our fixed pricing on our website. As a thank you for joining us today, we want to offer you a $50 discount on your initial consultation. With this presentation being step 1 and that initial consultation being step 2, step 3 is the signing of the engagement agreement where you become a formal TuckerAllen client. After we've drafted your documents, you'll have the opportunity to review them. Then we'll move on to the signing meeting where you can walk away with a complete estate plan. TuckerAllen also offers virtual consultations where you can meet with one of our attorneys for the entire process from engagement to signing from the safety and comfort of your own home. Thank you again for joining us, and we hope to see you soon.